Okay, so we are going to start with our first topic, and that is union and its territory. Okay, so in this chapter, we are going to learn what are the different provisions and articles related to union, and what constitution gives power to the parliament, and what are the issues, right? So first, we are going to start. Okay, so in Indian Constitution, Article 1 to Article 4, under Part 1 of the Constitution, Part 1 of the constitutions deals with union and its territory. So one by one we will see what is union here and what is its territory. So in our constitution, article 1 to article 4, okay, it means article 1, article 2, article 3 and article 4 under part 1 of the constitution deals with the union and its territory. So first we are going to start with Article 1, that what is Article 1 and what it provides. So Article 1 describe that, or basically we can say Article 1 tells us the or describe the name of the country. Article 1 describe the name of the country. Okay, and what is the name of the country? So Article 1 describes India, that is Bharat, shall be a union of state. India, that is Bharat, shall be a union of state rather than federation of states. Rather than federation of states. Okay, so this is what Article 1 is describing. Article 1 is describing the country name, that is India, India, that is Bharat. So recently in the past we have seen there was controversy when there was G20 going in our country. So we have seen that president has used a name, or you can say the name board as president instead of president of Bharat, instead of president of India. We have seen that president has written his name as like president of Bharat, right? Instead of president of India. So most of the people started telling that government is going to change the name. It is going to from India to Bharat, but this is not. Article 1 clearly describes both the name, India and Bharat. India, this is the ancient name. Okay, this is the ancient name, and this is the name uh, constituted during the Constitutional Assembly. Okay, so it describes India, that is Bharat, shall be a union of state rather than federation of state. So this thing we have to understand, that what is union here, right, and what is federation here. So before understanding what is federation, let's understand what is federalism, right? So we have to understand first what is federalism. So federalism is what? So it is basically a system of polity having multiple level of government, having multiple level of government with well-defined function, with well-defined functions. So multiple level of government, what means, like if we see another country in India, so we have a multiple level of government, like we have central government, right? We have state governments, we have local government. So different levels of governments we are having. So federalism is what? It is a system of polity having multiple level of government with well-defined function. And we can see that our country have different level of governments, and they have well-defined function, right? So like central government is having a function of like controlling the international affairs, defense sectors, right? State government has function like taking care of agriculture, and local government. looking for the rural development and all, right? So in what is federalism? So in basically federalism means there will be in a country there will be a multiple level of government with well-defined function, right? So what are the important features of federalism? We will just point it right now. So features of federalism. So what are the features of federalism? So we don't need to memorize. This we can answer with just common sense. Okay, if we look after our country. So in India, if we say that India follows the federal characteristic. Okay, India is a federal country. We say okay. And what is federal? It means multiple level of government. So in our country, if we will see, if we are a federal country, so what are the features of federalism? So in our country, we can see we have a written constitution, right? We have a written constitution. Then we have a bicameral legislature. What does bicameral legislature means? It means two houses, right? Like in India, we can see we have a upper house, that is Raj Sabha, and we have lower house, right? That is Lok Sabha. Similarly, in USA and UK, we have two houses are there also. So bicameral legislature, written constitution, and what can be next? What can be next? So there in our country we have independent judiciary, independent judiciary. Just a second. We have independent judiciary. We have, right, and then we have a separation of power, or we can say there are division of subjects. Okay, so center has its own subject, state has its own subject. So there are division of subjects, or we can also say separations of power. So in our country, we can see powers are separated. Executive has its own power, legislature has its own power, right? So separation of power is also there. So these are the features of federalism. There will be a written constitution. There is a bicameral legislature, independent judiciary, division of subject, and separation of power. So these are the features of federalism. Now we will move back in Article 1. So in Article 1, it is describing the name India Desh Bharat. Now we will understand what is this union of state rather than federation of state. Although India is a federal country, so why we have specified this thing, or why you can say the constitution makers has still that it is a union of state. We can also say that it was a federal state. Why? But why constitution maker has still that why it is union of state rather than a federation of state, even though we are a federal country, right? So because we will understand this with an example of America or USA, we can say. So in USA, what happened? Let me just tell you. So in USA, all the states of USA was existing before the constitution was made. Okay, कहने का क्या मतलब हुआ कि जितने भी स्टेट थे यूएसए में वो ऑलरेडी एग्जिस्टेड थे. दे वर नॉट क्रिएटेड आफ्टर मेकिंग ऑफ कॉन्स्टिट्यूशन, राइट? So all the states of USA were pre-existed, okay, and they came together to form a nation that we call as United States of America, right? So they come together to form a nation. So in this approach, what was happened? In this approach is that the power was transferred from bottom to top. Okay, and that's why USA they say they are a federal state, and they are a federal state, right? It means, okay, it means what? That in USA it is indestructible union, that is central government, you can say indestructible union of undestructible state. It means that in USA, state's boundary, state's name, or state size cannot be altered without the permission of states. Okay, like in India, if we see, like in India, if recent example we will see that in Andhra Pradesh, Telangana was separated, okay, by a law. by will, that we will see how we can separate the state boundaries, okay, how we can separate states from one state to another, how we can merge the states, right? So that thing we will see in the coming lecture. So in USA, states cannot be altered without their permission. State names cannot be changed without their permission. So that's why it is called that USA is indestructible union of undestructible states, right? But on the other hand, if we look on India, if we look India, so when India got independence, so British transferred the power to the Dominion of India, right? And this Dominion of India forms the constitution, okay, forms constitution, and through this constitution they recognize the state, right? It means what? If we understand it very in simple language, that in the case of India, state was not pre-existing, right? State was created after the formation of constitution, not before the constitution. So in case of India, power was transferred from top to bottom, right? So constitution is identifying the state. So through constitutional amendment or through passing some law, parliament, or you can say the central government, can change the size, can change the structure, can change the demographic of state, right? So in case of India, what we say, that it is indestructible union of destructible state. And in past we have seen that central government or our union has exercised those power, right? It means states can be destroyed, but union, that is India, it cannot be destroyed. So that's why our constitution maker has focused on this word union of state, because state was not pre-existing. The constitution has recognized the state, so that's why it is union of state rather than a federation of state. So this is what article 1 is. Now we will see, okay, so we can see also like this, that article 1 is what? Article 1 is just describing the name of the country. Okay, so now the countries make, okay, अब country form हो चुकी है, country का name हो चुका है, right? Now the country is sovereign. Country is what? Country is sovereign. Sovereign कहने का क्या मतलब हुआ? That country can make its own decision. No other countries can, you can say, influence their decision or pressurize it. So country is sovereign. So country can acquire the territories. Okay. अब country क्या कर सकता है? Country can acquire territories. Right? Country can acquire territories. Okay. But okay, a country can acquire foreign territories. We can write here specifically. Country can acquire foreign territories, but not like waging the war or just illegally occupying, right? So country can acquire foreign territories, but whatever the rules are mentioned in the international law. Okay, we can simple write here according to international law. According to international laws. So what is international laws? So simple, like some country gifted their territories to India, right? Or by plebiscite, right? Plebiscite, it means asking the people, taking the vote whether you want to be the part of India, Union of India, or you want to be separate, like we have done in the past after India's got independence. We have asked several other princely states to join us, okay, by plebiscite there, or simply they can purchase or gift or lease. So through international law, a sovereign nation can acquire foreign territories. Okay. So suppose not territories acquired. Suppose India acquire uh, if we talk India, so like Goa was recaptured, or you can say Hyderabad. In the case of Hyderabad, India acquired the Hyderabad. Okay. Now, suppose if the country has acquired some foreign territories, so how it is going to be merged? There must be some law, right? There must be some law that is guiding the state, that is guiding the union to merge it at a state or make a union or form a union from that. Okay, so for that purpose, we have another article, and that article is what? That is Article 2. Okay, so simply we can remember in that way that Article 1 is describing the name, and Article 2 will be give us, or the Article 2 will be provide what? Article 2 will be provide that Parliament through a law can admit any foreign territories into the Union or establish a new state. ओके या तो वो यूनियन बना सकता है या एक वो न्यू स्टेट बना सकता है इन अ मैनर एज फाउंड सुटेबल बाय द पार्लियामेंट. Okay, so what article 2? So article 2 provides that parliament. Why parliament? Because it is our central government, it is our union. Okay, article 2 provide that parliament may by law admit any foreign territories into the state. Okay, any foreign acquired territories. Okay, admit into the states और फॉर्म अ यूनियन, या तो यूटी बना सकते हैं यूनियन टेरिटरी. ओके, और फॉर्म अ यूनियन. ओके, और इस्टेब्लिश अ न्यू स्टेट, या एक न्यू स्टेट भी बना सकते हैं. इस्टेब्लिश अ न्यू स्टेट विच एवर इज फाउंड सुटेबल, विच एवर इज फाउंड suitable by the parliament. Sorry, whichever is found suitable by the parliament. So this is what article 2 is. Okay, so article 2 is what? So article 2 is basically providing, okay, article 2 is describing that parliament may by law. Okay, parliament law के थ्रू किसी भी acquired territory को किसी state में admit कर सकते हैं. Suppose we can say, we can take as an example like Jammu and Kashmir. Okay, or Jammu and Kashmir, not so suppose there is some part of Pakistan, you can say, like any part of the Pakistan. Suppose, okay, I'm just telling, suppose this is not the real scenario. So suppose some territories of Pakistan is occupied by India, okay, or acquired by India by the international law, not illegally, by the international law. Now what government can do? Either they can merge into the existing state. Okay, like suppose the acquired territories are near the border of Punjab, so they can merge it into the Punjab, or they can form a union, like we have Andaman and Nicobar Island, right? Union territories. Okay, or we can establish a new state. तो इन सभी में से जो भी फाउंड सुटेबल होगा पार्लियामेंट का, दे कैन डू इट. Okay, so there was a very famous case in this regarding to this article. So there was a case, that is RC Podial case. Okay, RC Podial case. Sorry. So in the RC Podial case, 1993, so Supreme Court held that Parliament Supreme Court held that the Parliament can integrate any acquired territories using an ordinary law. Okay, using an ordinary law under Article 2. Under Article 2 in the following manner. A manner क्या है, that I will tell you, but for now understand that what Supreme Court has told. Supreme Court in RC Podial case 1993, Supreme Court told that, or held that Parliament can integrate any acquired territories using an ordinary law. It means what is telling that Parliament does not need to has to pass some special law. Okay, in an ordinary law, by simple majority, Parliament can pass any law. So it does not require a full majority or kind of that. So by an ordinary law, under Article 2, Parliament can integrate any territories in the following manners. Now, what are the manners? Okay, what are the manners? So, what Parliament can do? So, Parliament can merge, as I told you, merging the territory into an existing state. So, suppose there is some territory. So, merging the territories into an existing state, right? And establishing a new state, we can also establish a new state from it, establishing a new state, or establish a new state Okay, establish a new state with some special provision, okay, or with some special feature, you can say. Establish a new state with some special features, with some special feature within the federal framework of the constitution. It means कि हम लोग constitution के बाहर जाके कुछ special features नहीं कर सकते हैं. Within the constitution framework we can give that. So within the federal framework of constitution, within the federal framework of constitution. All right. So what manner? So we can simply merge the territory into an existing state, establish a new state, or establish a new state with some special features. अब जैसे हम लोग देख सकते हैं like from the fifth and sixth schedule. Okay, like from the fifth sixth schedule of the states, there are some states which are in the fifth and sixth schedule. So according to that, we have given the administration like some separate provision for their respect to the administration of scheduled areas and tribal areas within the state, right? So some special features we can provide that. So this is what Article 2. So now again I will recap. So Article 1 is what? Article 1 is just describing the name of the country. Article 2 is telling us not the country is sovereign, so they can acquire some foreign territory. So when suppose India has acquired some foreign territory, so there must be a law through which they can admit into their union. Okay, randomly नहीं कि हमने acquire कर लिया वो हमारा पास हो गया union में. So there must be a law which is telling us how we can if there must be a law which is stating us or which is giving us the direction that how we can okay establish or how we can admit it into the union that acquired territories. So here article 2 is telling us that okay that parliament may by law admit into the states or form a union. Now we will see the next article. Okay, now we have seen in our country that time to time we see there are some internal restructuring of the states. Like in the past we have seen in 2000 Jharkhand was cut out from the Bihar and made a separate state. Okay, similarly in recent year in 2014 we have seen that Telangana was separated from Andhra Pradesh and created a new state, right? So similarly from the time of independence we have seen that most many for better administration. Okay, why we separate the state? Just because for the better administration we separate out the states. So which article is telling us that, or which law is telling us that how we can separate the state? There must be some law which should be guiding us. So for that purpose we have a third article, and that is article 3. Okay, so now we will see article 3. Okay, so what is article 3? So article 3 basically provides internal restructuring of, okay, or we can say internal reorganization of the country. So article 3 is what? Article 3 provides internal reorganization of the country. Okay, and it is also telling in which manner we are going to internal reorganization of the country. So what are the manner in which we can you can say do the reorganization or restructuring? So first what we can do, we can divide a state. हम लोग state को divide कर सकते हैं, dividing a state. Like Telangana was separated from Andhra Pradesh, dividing a state, और merging a state. हम लोग merge कर सकते हैं किसी state को एक दूसरे के साथ, merging a state. In the past we have seen that Gujarat state was merged with the Bombay state in during the time of 1950s, okay, after the independence. So we can merge a state, or we can merge territory. हम लोग territory को भी merge कर सकते हैं, UTs, merging a territory. और वी कैन से मर्जिंग अ टेरिटरी, मान लो कुछ स्टेट्स हैं उनके टेरिटरी को हम लोग क्या कर सकते हैं, मर्जिंग अ टेरिटरी ऑफ सम स्टेट्स. Okay, suppose there is some border dispute, like suppose Chhattisgarh, Odisha, or Madhya Pradesh. Okay, right. So the border areas of this states are having some issue. So what central government can do? To merge a territory of some state into another. तो अदर स्टेट के साथ हम लोग उसको मर्ज कर सकते हैं, राइट. व्हाट सेकेंड थिंग वी कैन डू, वी कैन इंक्रीज द साइज. हम लोग स्टेट के साइज को इंक्रीज कर सकते हैं. वी कैन ऑल्सो डिक्रीज द साइज, राइट. We can also alter the boundaries of state. So these are the things that we can do in internal reorganization or restructuring. Or we can also change the name of state. So changing the name of states, right? So this is what we can do in the internal reorganization of the country. Like we have seen in the past, Uttarakhand was earlier named as Uttaranchal and then later changed to Uttarakhand. Uttar Pradesh was initially named as United Provinces, but after independence we changed its name to Uttar Pradesh. Okay, so that thing we can do. And which article is telling for the internal reorganization? So that is Article 3. Okay, now when we are doing this, suppose when government is doing this, okay, when parliament is doing this, so any such change, okay, एनी इसमें से कोई भी चेंज, अब कोई भी रैंडम स्टेट ये काम नहीं कर सकता, स्टेट असेंबली कैन नॉट डू दिस. ओके, स्टेट असेंबली कैन नॉट merge themselves into another state without having the permission of parliament. Okay, तो स्टेट लेजिस्लेचर ये बिल पास नहीं कर सकता. तो एनी सच चेंजेस, इसमें से कोई भी चेंज, ओके, एनी सच चेंज, any such change shall be introduced in parliament, shall be introduced only by the parliament. सिर्फ पार्लियामेंट के थ्रू ही ये सारे चेंजेस इंट्रोड्यूस हो सकते हैं या हो सकते हैं. एनी सच चेंजेस शैल बी इंट्रोड्यूस ओनली बाय द पार्लियामेंट बाय अ लॉ, एक लॉ के थ्रू. ओके, लाइक वी पास अ बिल, एक बिल पास होगा उसके लिए, एंड आफ्टर दैट देयर विल बी वोटिंग ऑन दिस. इफ द बिल इज पास, दैट विल बिकम अ लॉ और एक्ट. ओके, सो बाय द पार्लियामेंट बाय अ लॉ, ओके, provided that following conditions are fulfilled. Following conditions are, इसमें से कुछ conditions है, right? Following conditions are fulfilled. अब क्या condition है? What are the condition? तो एनी सच चेंजेस हैव बीन इंट्रोड्यूस ओनली बाय द पार्लियामेंट, पार्लियामेंट के थ्रू ही ये सारे कुछ चेंजेस इंट्रोड्यूस हो सकते हैं लॉ के थ्रू. इसमें से क्या है कि अब कंडीशन पर फुलफिल होना चाहिए. ओके, एंड व्हाट आर द कंडीशन नीड टू बी फुलफिल्ड बिफोर इंट्रोड्यूसिंग दिस एज अ लॉ इन द पार्लियामेंट. पार्लियामेंट में जब हम इसको एज ए लॉ या एज ए बिल के तरह प्रपोज कर रहे हैं, ओके, टेबल कर रहे हैं, तो उससे पहले हमें कुछ कंडीशंस का ध्यान रखना है. दैट कंडीशन मस्ट बी फुलफिल्ड, एंड इफ दैट कंडीशन इज नॉट फुलफिल्ड, देन दिस changes cannot be introduced in the parliament. Okay, so what are the condition? So let me just tell you what are the conditions. So first condition is what? The proposal for such change. Okay, ये जो proposal होगा, proposal for such change can only be, okay, or you can say may only be or may be introduced in either houses of parliament. Okay, अब इसको obviously बात है, हमें parliament में लाओ, इससे parliament में as a law प्रस्तुत करना है हमें. ओके, हमें टेबल करना है पार्लियामेंट में. अब पार्लियामेंट में क्या है कि राज्यसभा भी है हमारे पास और लोकसभा भी है हमारे पास. तो अब इसमें से किस हाउस में हमें सबसे पहले लेके जाना पड़ेगा? तो इसमें बताया गया है कि एनी सच चेंजेस, ओके, द प्रपोजल फॉर सच चेंजेस मे बी इंट्रोड्यूस इन आइदर हाउस ऑफ पार्लियामेंट. मतलब क्या हो गया कि हम राज्यसभा में भी ला सकते हैं, हम चाहे तो लोकसभा में भी ला सकते हैं, डिपेंड्स अपॉन द सेंट्रल गवर्नमेंट. ओके, एंड ओनली ऑन द रिकमेंडेशन ऑफ प्रेसिडेंट. जब प्रेसिडेंट रिकमेंड करेंगे इस चेंज के लिए, तभी आप इस प्रपोजल को आप किसी भी हाउस में आप ला सकते हो. सो प्रपोजल फॉर सच चेंज मे बी इंट्रोड्यूस इन either houses of parliament only on the recommendation of president, only on the recommendation of president. प्रेसिडेंट के रिकमेंडेशन पे ही हम लोग इस लॉ को किसी भी हाउस में प्रेजेंट कर सकते हैं, टेबल कर सकते हैं, राइट? सेकेंड कंडीशन इज व्हाट इज सेकेंड कंडीशन टेलिंग? द सेकेंड कंडीशन इज टेलिंग दैट द जो प्रेसिडेंट जो है, जब ये जो प्रपोजल है, प्रेसिडेंट क्या, व्हाट प्रेसिडेंट विल डू, प्रेसिडेंट शैल सेंड दिस प्रपोजल और सेंड द प्रपोजल टू सीक द ओपिनियन ऑफ द रिस्पेक्टिव स्टेट. अब जैसे सपोज करो हम लोग बिहार और झारखंड को अलग कर रहे हैं, ओके, और सपोज आंध्र प्रदेश एंड तेलंगाना को सेंट्रल गवर्नमेंट इज ट्राइंग टू सेपरेट इट. तो उस प्रपोजल को क्या करेंगे, वी विल सेंड इट टू द रिस्पेक्टिव स्टेट लेजिस्लेचर. द प्रेसिडेंट व्हाट नॉट वी, what president will do, president will send the proposal to seek the opinion of the respective states. So in the case of Andhra Pradesh, so Andhra Pradesh state legislature के पास वो proposal जाएगा to seek their opinion what they are telling. ओके, विद इन द टाइम, और जब ये प्रपोजल भेजा जाएगा स्टेट लेजिस्लेचर के पास, तो उसके साथ टाइम भी स्पेसिफाई किया जाएगा प्रेसिडेंट का। ओके, कि इतने टाइम में आपको अपना ओपिनियन देना है बिफोर सेंडिंग टू द पार्लियामेंट। पार्लियामेंट देखो, पार्लियामेंट में इंट्रोड्यूस होने से पहले क्या होगा कि प्रेसिडेंट व्हाट विल डू, देखो प्रेसिडेंट क्या करेगा, प्रेसिडेंट फर्स्ट व्हाट प्रेसिडेंट विल डू, प्रेसिडेंट फर्स्ट सेंड दिस प्रपोजल टू द स्टेट रिस्पेक्टिव स्टेट लेजिस्लेचर, okay, to seek the opinion, and also president will specify the time, okay, कि आपको इतने टाइम में ओपिनियन अपना देना है। उसके बाद क्या होगा, आफ्टर दैट इट विल बी टेबल इन द पार्लियामेंट, राइट। सो सेकेंड कंडीशन क्या कह रहा है कि प्रेसिडेंट shall send the proposal to seek the opinion of respective state legislature, right, to seek the opinion of respective state legislature within the time specified by the president before sending it to before sending to the parliament, okay, पार्लियामेंट में भेजने से पहले। अब देखो क्या होगा, अब जब ओपिनियन प्रेसिडेंट ने आस्क किया है, ओके, व्हेन प्रेसिडेंट हैज सीक द ओपिनियन, राइट, ऑफ रिस्पेक्टिव स्टेट, तो अब क्या हो सकता है, कुछ केसेस में स्टेट बोले हाँ वी आर रेडी, यू कैन सेपरेट अस, ओके। कुछ केसेस में क्या हो सकता है कि स्टेट विल सेंड देयर ओपिनियन दैट नो वी डोंट वांट टू बी सेपरेट, वी नीड टू बी एन इंटीग्रेटेड, you should not separate us as a Telangana and Andhra Pradesh, there will be a huge loss, or there will be huge loss to our economy, something kind of that. So what in that case what president can do, okay, is the opinion of state assembly is binding on the parliament, क्या जो ओपिनियन स्टेट असेंबली से हमारे पास पार्लियामेंट के पास आया है, सो दैट ओपिनियन इज बाइंडिंग ऑन द पार्लियामेंट और नॉट। सो इट आल्सो स्पेसिफाइड कि जो ओपिनियन होगा, ओके, ओपिनियन ऑफ स्टेट असेंबली is not binding on parliament, okay, is not binding on parliament, okay, so that opinion of state assembly is not binding। and in case of union territory, अब union territory क्या हो, that is already run by its administration run by central government, so this opinion is not required, okay। so assembly of UT is not required under is to be referred under this opinion, मतलब उनसे ओपिनियन पूछा भी जा सकता है, नहीं भी पूछा जा सकता है, there is no mandatory, but in case of state assembly, so president send the proposal, okay, but in case of UT it is not, okay, so we can simplify assembly of UT is not required to refer under this opinion, to refer under this opinion, okay। So there is a very famous case related to this article, okay, and what is that case, let me just tell you, okay। So in the Babulal Parathe case 1960, okay, so there was a case, okay, so there was a case that was Babulal Parathe case, so in 1960 the Supreme Court held that opinion of state assembly is not binding on the parliament, so there was a case like in the Supreme Court there was a case registered that whether the state assembly opinion is binding, should be binding on the parliament or not. So in the Babulal Parathe case, Supreme Court held what, that the opinion of state assembly is not binding on the parliament, okay, so it is just a procedural formality, okay, ये क्या है फॉर्मेलिटी है प्रोसीजर का, रिक्वायर्ड टू इंश्योर कि जो प्रिंसिपल ऑफ नेचुरल जस्टिस है वो फॉलो हुआ है, ओके, प्रिंसिपल ऑफ नेचुरल जस्टिस फॉलो हुआ हो, इसके लिए क्या होता है कि ये जो ओपिनियन है ये स्टेट गवर्नमेंट को भेजा जाता है ताकि उससे भी ओपिनियन ले सके, ताकि एक प्रिंसिपल ऑफ नेचुरल जस्टिस फॉलो। प्रिंसिपल ऑफ नेचुरल जस्टिस क्या हो गया कि हम लोग सभी पार्टी से सुने क्या उसका ओपिनियन क्या है, ओके, So suppose there are three-person ABC and A is taking decision on behalf of C. So it should hear what C is also telling. Okay. So to hear all the parties, no one shall be judge of his own case. Okay, कोई भी अपने ही केस का जज नहीं होगा. And no one shall be biased as a judge. So these are the principle of natural justice. So we can simply write here in the Babu Lal Parate case 1960. Okay, so Supreme Court held that, okay, opinion of state assembly not binding on parliament. Okay, not binding on parliament. ये क्या है? It is just a procedural formality. It is a procedural formality. Okay, ensure required to ensure that principle of natural justice are followed. Okay, procedural formality है required to ensure that principle of natural justice is followed. Okay, so this is what आर्टिकल 3. अब देखो आर्टिकल 2 में भी क्या है. ओके, हम लोग स्टेट्स की बात करते हैं. आर्टिकल 3 में भी वी आर टॉकिंग ऑफ द स्टेट. ओके, बट देयर इज अ डिफरेंस इन आर्टिकल 2 एंड आर्टिकल 3. तो व्हाट इज द डिफरेंस? तो आर्टिकल 2 जो है, ओके, इट इज रिलेटेड टू द एडमिशन और एस्टेब्लिशमेंट ऑफ न्यू स्टेट. ओके, विच इज नॉट अ पार्ट ऑफ यूनियन ऑफ इंडिया. तो आर्टिकल 2 क्या है? उन टेरिटरीज की बात कर रहा है. ओके, उन टेरिटरीज के एस्टेब्लिशमेंट की बात कर रहा है विच इज नॉट पार्ट ऑफ यूनियन ऑफ इंडिया, विच इज नॉट पार्ट ऑफ यूनियन ऑफ इंडिया. राइट. बट आर्टिकल 3 क्या है और आर्टिकल 3 क्या कर रहा है? सो इट इज टॉकिंग और इट इज रीस्ट्रक्चरिंग द इंटरनल स्टेट्स. Okay, or you can say the existing state which is already existing, which is already part of union of India. Okay, so this is what article 3 is and this is what article 2 is. Right. Now we will talk about our last article which is related to union and its territory. So we have seen there are three articles: article 1, then article 2, then article 3, and we will see article 4 now. Okay, so let me just article 4. Okay, so what article 4 is telling. Okay, अब suppose करो article 2 और article 3. Okay, suppose in parliament article 2 article 3 के through कुछ changes हुए. Okay, like there is some establishment of new state or there is some internal restructuring of state. So what article 4 is telling, so when a bill is introduced in a parliament, जब कोई भी bill introduce हो parliament में using article 2 और 3. अब आर्टिकल 2 और 3 क्यों? क्योंकि आर्टिकल 2 और 3 के थ्रू क्या हो रहा है? आर्टिकल 2 और आर्टिकल 3 के थ्री आर्टिकल 2 और आर्टिकल 3 के थ्रू क्या हो रहा है कि नया स्टेट इस्टेब्लिश हो रहा है या फिर सेपरेट हो रहा है या इंटरनल रीस्ट्रक्चरिंग हो रहा है. तो जब कोई भी बिल इंट्रोड्यूस हो पार्लियामेंट में यूजिंग आर्टिकल 2 और आर्टिकल 3, इट शैल आल्सो इंट्रोड्यूस द रिक्वायर्ड चेंजेस टू फर्स्ट एंड फोर्थ शेड्यूल. ओके, तो जो चेंजेस आर्टिकल 2 और 3 के थ्रू हो रहा है, जो भी रिक्वायर्ड चेंजेस होगा फर्स्ट और फोर्थ शेड्यूल में, वो उसके साथ ही लाया जाएगा. ओके, अब देखो फर्स्ट और फोर्थ शेड्यूल क्या है. सो बिफोर टेलिंग यू, जस्ट अ सेकेंड. फर्स्ट शेड्यूल में क्या है? तो फर्स्ट शेड्यूल में क्या है? ओके, सो इन द आर्टिकल 1, ओके, आई जस्ट मिस्ड वन थिंग. So Article 1 is describing the name of the country. India Bharat shall be union of state rather than federation of state. और साथ ही साथ आर्टिकल 1 और क्या बता रहा है? आर्टिकल 1 ये भी बता, it further provide that all the names, okay, all the names of state and UTs of India, okay, and UTs of India will be shall be mentioned in first schedule. Okay, तो जितना भी नेम है, ओके, स्टेट्स का जितना भी नेम है स्टेट्स का, राइट, ऑल द नेम्स, ऑल द यूटीज दैट इज पार्ट ऑफ इंडिया, तो वो किस शेड्यूल में मेंशन है? वो हमारे फर्स्ट शेड्यूल में मेंशन है. सो लिस्ट ऑफ ऑल स्टेट एंड टेरिटरीज आर मेंशन इन शेड्यूल फर्स्ट. सो लिस्ट ऑफ ऑल स्टेट एंड टेरिटरी. तो अब ऑब्वियसली सी बात है, अगर आर्टिकल 2 और आर्टिकल 3 के थ्रू, सपोज आर्टिकल 2 के थ्रू कोई एक नया स्टेट ऐड हो गया, तो अब इस लिस्ट को भी हमें चेंज करना होगा, राइट. और फोर्थ शेड्यूल क्या है? ओके, शेड्यूल 4. व्हाट इज शेड्यूल 4? सो शेड्यूल 4 एलोकेट सीट्स इन राज्यसभा अमॉन्ग डिफरेंट स्टेट्स एंड यूटी. तो राज्यसभा में हर एक स्टेट का जो भी सीट्स होगा वो एलोकेट करता है शेड्यूल 4. तो अब अगर नया स्टेट फॉर्म हुआ या कुछ सेपरेशन ऑफ स्टेट्स हुआ, लाइक आंध्र प्रदेश एंड तेलंगाना, तो तेलंगाना के भी राज्यसभा का सीट होना चाहिए, तो वो चेंजेस भी हमें शेड्यूल 4 में करना होगा. So that's what Article 4 is telling. It provides that, okay, it provides that when a bill is introduced, okay, जब कोई भी bill introduce हुआ, when a bill is introduced in a parliament, sorry, when a bill is introduced in a parliament using Article 2 or 3, using Article 2 or 3, it shall also introduce, it shall also introduce the required changes to the first and fourth schedule, to the first and fourth schedule along with it. मतलब सेपरेटली नहीं करना है, उसके साथ ही, इसी बिल के साथ ही हमें जो भी चेंजेस होगा, रिक्वायर्ड चेंजेस फर्स्ट और फोर्थ शेड्यूल में, इसके साथ कर देना है. इट इज ऑल्सो व्हाट टेलिंग कि कोई भी चेंजेस, ओके, नो सच चेंजेस to first and fourth schedule shall be deemed to be a constitutional amendment. I will tell you what I am writing here. So no such changes to first and fourth schedule shall be deemed to a constitutional amendment under Article 368. Okay, under Article 368. So what I have written here, okay. So first of all, I think you have understand that when a bill is introduced in a parliament using Article 2 or 3, it shall also introduce a required changes to the first and fourth schedule, right? तो फर्स्ट और फोर्थ शेड्यूल में अलॉन्ग विथ इट, तो फर्स्ट और फोर्थ शेड्यूल में भी चेंजेस करना होगा. तो अब इन दोनों को अलग अलग हम लोग नहीं लाएंगे, इन दोनों को हम लोग साथ में ही ले आएंगे. सेकेंड व्हाट इज टेलिंग कि कोई भी चेंजेस जो फर्स्ट और फोर्थ शेड्यूल ऑफ कॉन्स्टिट्यूशन में होगा वो तुम्हारा कॉन्स्टिट्यूशनल अमेंडमेंट नहीं होगा. ओके, लाइक फर्स्ट और फोर्थ शेड्यूल में अगर हम लोग कुछ भी चेंजेस कर रहे हैं, सो दैट डज नॉट बी डीम टू बी अ कॉन्स्टिट्यूशनल अमेंडमेंट. जैसे हमने देखा है प्रीवियसली 71 अमेंडमेंट एक्ट और 72 अमेंडमेंट एक्ट और 105th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट. So we don't need to do that. Okay, under Article 368. So from here we can also understand. Okay, we can also understand this thing that Article 4 allows amendment to first and fourth schedule. Article 4 allows the amendment to the first and fourth schedule through a simple majority. मतलब क्या हो गया कि अगर हमें कोई भी चेंजेस करना होगा स्टेट्स में, तो वी कैन डू थ्रू द सिंपल मेजोरिटी यूजिंग एन ऑर्डिनरी बिल rather than a constitutional amendment. ओके, सो दिस इज व्हाट आई एम ट्राइंग टू टेल यू कि कोई भी चेंजेस जो फर्स्ट और फोर्थ शेड्यूल में हो गया, सपोज करो सिंपल अगर एग्जांपल हम लोग समझे कि अगर हम लोग आंध्र प्रदेश और तेलंगाना को सेपरेट कर रहे हैं, तो उसके लिए हमें कोई भी कॉन्स्टिट्यूशनल अमेंडमेंट की जरूरत नहीं है. वी कैन सिंपली डू इट बाय पासिंग एन ऑर्डिनरी लॉ. ओके, बाय पासिंग एन ऑर्डिनरी बिल, सिंपल मेजोरिटी के थ्रू हम लोग, ऑर्डिनरी बिल के थ्रू हम लोग उसको सेपरेट कर सकते हैं rather than to be a constitutional amendment. अब ऑर्डिनरी सिंपल मेजोरिटी कहने का क्या मतलब हो गया? वी डज नॉट रिक्वायर फुल मेजोरिटी और स्पेशल मेजोरिटी इन दैट केस टू चेंज अ पार्टिकुलर बाउंड्री और अल्टरिंग द नेम ऑफ द स्टेट. So this is what the four articles which are related to union and territory. So article 1 is what? It is describing the name of the country, and it is also telling all the name and state shall be mentioned in the first schedule. Okay, right? And it is we have also understood that why it is union of state rather than federation of state, right? And we have understood what is federalism. So basically it is a multiple level of government with well defined functions. Okay, features of federalism that we have understand, and we have understand, as I told you, that why it is union of India rather than federation of states. Then we understand that now India is a sovereign country, so it can acquire any foreign territories, whichever guidelines is provided by the international law. Okay, so when some territory is acquired by India, so there must be a law which should guide it, the union. So we have Article 2, which provides that Parliament may by law acquire any foreign territory and admit into the states, or form a union or establish a new state with जो भी suitable found होगा Parliament से, right? And simply article 3, internal reorganization of the country, and article 4 is telling कि कोई भी अगर बिल हम लोग इंट्रोड्यूस करें पार्लियामेंट में यूजिंग आर्टिकल 2 और 3, so it will also introduce the required changes, जो भी changes होगा फर्स्ट एंड फोर्थ शेड्यूल में उसी के साथ ही, उसी बिल के साथ ही, ओके, अलग से हमें सेपरेटली लाने का जरूरत नहीं है. Okay, now there are some issue that we will talk. Okay, so now in this we will talk some of the issue that were in past. Okay, so first issue we will understand, can Indian territory be given to, or can Indian territory be given to another country? क्या सेंट्रल गवर्नमेंट, ओके, जो यूनियन गवर्नमेंट हमारी, क्या वो कोई भी टेरिटरी किसी अदर कंट्री को दे सकती, कैन इट गिव? ओके, सो बेरूबेरी केस, ओके, बेरूबारी केस 1960 में, ओके, सुप्रीम कोर्ट ने बोला, ओके, सुप्रीम कोर्ट हेल्ड दैट कोई भी टेरिटरी, ओके, एनी टेरिटरी विच इज अ लीगली पार्ट ऑफ इंडिया, ओके, कोई भी टेरिटरी है, ओके, सुप्रीम कोर्ट SC हेल्ड दैट एनी टेरिटरी, okay, any territory which is a legally part of India can be given away only by constitutional amendment. Okay, अब जैसे अभी तक क्या था कि हम लोग किसी भी एक्वायर्ड स्टेट को हम लोग यूनियन में एडमिट कर रहे थे या फिर इंटरनल रीस्ट्रक्चरिंग कर रहे थे, हम लोग तेलंगाना को आंध्र प्रदेश से सेपरेट कर रहे थे द सेंट्रल गवर्नमेंट, बट वो सारा चीज क्या हो रहा था, स्टेट के अंदर में हो रहा था, राइट? सो एक क्वेश्चन राइज हुआ कि क्या इंडियन टेरिटरी जो है वो यूनियन गवर्नमेंट हमारे किसी अदर कंट्री को, जैसे पाकिस्तान को दे सकती है या बांग्लादेश को दे सकती है. सो बेरूबारी केस 1960 में सुप्रीम कोर्ट ने बताया कि जो टेरिटरी है, जो भी कोई भी टेरिटरी है जो लीगली पार्ट ऑफ इंडिया है, वो दिया जा सकता है अनदर कंट्री को only by a constitutional amendment under Article 368. Okay, SC held that any territory which is legally part of India can be given away. Okay, can be given away only by a कॉन्स्टिट्यूशन. अब इसके लिए क्या है, इसके लिए हम लोग सिंपल बिल या ऑर्डिनरी बिल के थ्रू हम लोग नहीं कर सकते, इसके लिए हमें क्या है, हमें कॉन्स्टिट्यूशनल अमेंडमेंट करना होगा. सो वी नीड टू pass a special law with full majority or special majority, given only by constitutional amendment under Article 368. ओके, तो जैसे प्रीवियसली पास्ट में हमने देखा, ओके, फॉर एग्जांपल वी विल सी, फॉर एग्जांपल इन द पास्ट 100 कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट 2015. ओके, 100 कॉन्स्टिट्यूशनल, ये प्रीलिम्स में हो सकता है, इट कैन बी आस्क्ड, इट माइट बी पॉसिबल. 100 कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट 2015 was passed, okay, to exchange enclave with Bangladesh, to exchange enclave with बांग्लादेश. तो इसमें क्या हुआ था, कि अंडर दिस कॉन्स्टिट्यूशनल अमेंडमेंट, ओके, इंडिया ने क्या किया था, इंडिया ने ट्रांसफर किया था 111 इनक्लेव्स टू बांग्लादेश, ओके, टू बांग्लादेश। और बांग्लादेश ने क्या किया था, ओके, व्हाट बांग्लादेश हैड डन, सो बांग्लादेश हैज ट्रांसफर्ड 51 इनक्लेव्स, बांग्लादेश ने 51 इनक्लेव्स ट्रांसफर किए थे इंडिया को, ओके। So yes, Indian territory can be given to another country, but only with the constitutional amendment under Article 368. For example, 100 constitutional amendment we have done in the past, okay, in 2015 to exchange enclave with the Bangladesh, and in this constitutional amendment, India's share or India transfer 111 enclaves to Bangladesh, and Bangladesh transfer 51 enclaves to India, right? Now, second issue we will talk. So second issue is settlement of boundary dispute. अब suppose करो there is some, अब अगर they inside the country if there is boundary dispute, then it can be resolved. Suppose there is some boundary dispute between Bihar and Uttar Pradesh, and suppose center has passed some law regarding to that, and Bihar has, you can say Bihar go to Supreme Court. So Supreme Court in there they can take any action or they can instruct the central government if that is okay. But what in the case of if there is if there is boundary dispute with foreign nation, foreign countries or with our neighbor, okay. So this is what we are going to understand, settlement of a boundary dispute and what Supreme Court has stated. Settlement of boundary dispute. So in the Ishwar Bhai Patel case 1969, इन केसेस को याद रखना आप लोग। बेरुबारी केस 1960 में सुप्रीम कोर्ट ने हेल्ड किया था कि कोई भी टेरिटरी जो लीगली पार्ट ऑफ इंडिया का वो दे सकती है भारत सरकार थ्रू कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट, ओके। एंड द सेकेंड, ये सेटलमेंट ऑफ बाउंड्री डिस्प्यूट में है, तो इन द ईश्वर भाई पटेल केस 1969 में, ओके, सुप्रीम कोर्ट हेल्ड दैट दैट सेटलमेंट ऑफ बाउंड्री डिस्प्यूट, जो भी बाउंड्री डिस्प्यूट का सेटलमेंट होगा, ओके, वेयर लीगल क्लेम्स ओवर द टेरिटरी इज नॉट वेल एस्टेब्लिश। मान लो जैसे अभी अरुणाचल प्रदेश पे जो भी लीगली क्लेम है, ओके, दैट इज नॉट वेल एस्टेब्लिश विद चाइना एंड इंडिया, सो समटाइम्स चाइना क्लेम्स ऑफ चाइना shows through the map, okay। So what Supreme Court tell that the settlement of boundary dispute where legal claim over the territory is not well established can be done by executive itself, okay। वो एग्जीक्यूटिव के थ्रू खुद एग्जीक्यूटिव उसे उस डिस्प्यूट को सेटल कर सकता है। इट डज नॉट रिक्वायर एनी कॉन्स्टिट्यूशनल अमेंडमेंट। मान लो जो भी बाउंड्री डिस्प्यूट है, ओके, और तो उसके लिए क्या है कि देर इज नो एज सच लॉ नीड टू बी पास इन द parliament. It does not require any constitutional amendment. It can be passed through simple majority or ordinary law, okay। So in the Ishwar Bhai Patel case 1969, SC held that, okay, SC held that Supreme Court, SC it means Supreme Court, that settlement of boundary dispute settlement of boundary dispute okay, settlement of boundary dispute where, जिसमें क्या है कि लीगल क्लेम वेयर लीगल क्लेम्स इज नॉट वेल, लीगल क्लेम्स ओवर टेरिटरी is not well established, okay, is not well established, can be done by executive itself, can be done by executive itself, okay। So it does not require constitutional amendment, does not require constitutional amendment, okay। And the third that we have discussed already, that the use of word union instead of federal in part 1, okay। जैसे वहां पे दिया हुआ इंडिया दैट इज भारत shall be a union of state rather than federal of state, right। तो वो चीज हमने पहले डिस्कस कर ली, why it is called as union and why it is called as federal। So this is what we need to learn in the union and its territory. So in the next lecture, we will do some of the prelims MCQ questions related to this topic. Okay. So thank you. That's all. We will meet in the next lecture.